Two strange animals, statutes of limitation and laches in debt law cases. Brought to you by Kenneth Chabert at yourlegallagat.com. Your advantage if you're being sued by debt collectors. If the debt collectors seem to take a long time getting around to sue you, there are two defenses to debt law cases you should consider: statutes of limitations and what is called laches. They are two rather strange animals in the law. Both rely on the passage of time, and both of them have a rather vague status in the law. And it isn't always clear how you should proceed if you want to assert them. The statute of limitations in civil law is the amount of time allowed by the law before the plaintiff must bring suit. That is, if a certain amount of time passes after the claim is ripe for litigation before you file suit, the action will be lost. Sounds simple maybe, but it isn't. A claim is ripe for suit after it is complete. In the case of debt law, this usually means upon default of payments. That is, when you don't pay when the bill is supposedly due, not when you incur the debt. So if a student has a loan, for example, that wasn't due for payments until out of school for a year, that year doesn't count. And credit card payments aren't in default until you miss the payment. If you make a payment after that, it could bring it out of default and restart the statute of limitations. That's one more reason debt collectors like to get any kind of payment they can from you. What do you do if the statute of limitations has passed, or run, as they say? This is where the statute of limitations status becomes a bit vague. It is certainly an affirmative defense, meaning that you must assert it and prove it. On the other hand, if the date of the default is included in the lawsuit, and the date is beyond the statute of limitations, you could file a motion to dismiss the claim. And this is because they've admitted the fact by including it in their petition. Some people file motions to dismiss even if the dates haven't been set out in the petition, and sometimes the courts will hear them on that basis too. Some courts have considered the statutes of limitation as a jurisdictional bar. That is, bringing the suit beyond the proper time bars the court from hearing it, and defendants can't waive the defense under that theory. Some courts in some jurisdictions may still follow that rule, but it's a good idea not to count on that. It makes better sense to assert the defense from the beginning if you know it, and if you find out in discovery that the time limit is passed, you could seek to amend your answer and include the defense then. It is probably possible to waive the defense by not asserting it in time. Courts have ruled that debt collectors suing to collect a debt beyond the statute of limitations is a violation of the FDCPA, the Fair Debt Collection Practices Act. It is an unfair debt collection practice because most collection suits, whether they have any validity or not, go unanswered, and that means that they default and the debt collectors collect the money. Therefore, if you discover that a claim has been brought against you beyond the statute of limitations, you should consider a counterclaim on this basis under the FDCPA. Laches, like statutes of limitation, is basically time-based. It's vaguer, though. The question there is, has so much time passed, even though the statute of limitations hasn't passed, that it would be unfair to allow the plaintiff to sue somehow? The court has to believe that the plaintiff waited for an unreasonably long time, and that the defendant has had something happen that reduced his chances to defend the case, and normally that something usually has to be the fault of the plaintiff. And here's a historical note about laches and statutes of limitation, because after all, why would you have statutes of limitation and this vaguer concept of laches? Well, that has to do with the history of the court. There was something called law and something called equity, and basically equity was where the king in England had essentially told his court not to uphold the law where upholding the law would result in something immoral. And so laches is one of the hangers-on of that idea, where the courts are permitted to take certain actions not normally recognized in the law to prevent something very unjust from happening. Because there's a statute of limitations to every action, one might think that it's never unreasonable to bring suit before the statute of limitations has run. And I'm not aware of any debt cases where laches has been argued and used as a defense successfully. But I suspect that laches might become an issue in the foreclosure cases that are kind of, coming through the courts these days. Because these cases involve so much dubious behavior on the part of the banks, the lenders, and because the lenders have been so careless with the backup documentation. There really could be prejudice there, what with the banks having played so fast and loose with all the records they could be missing, and nobody might have them. So one final note here: although I'm not aware of laches being treated as a basis for a counterclaim, one could certainly make the argument that collecting on a debt after so much time had passed, that the defendant's ability to defend was prejudiced, would be an unfair collection practice. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallagup.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it on YouTube, subscribe and friend me on YouTube, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.